Your Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning and welcome to council and to those watching on our Supreme Court live channel. I would ask Mr. Doug Shima, the clerk of the appellate court, to please call the 11 a.m. docket.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Friday, September 17th, 2021 consists of one case, appeal number 121682 and 1216823, the state of Kansas versus Jamario D. Roberts. Sedgwick County briefs both sides. Your Honor, the appellant has reserved 3 minutes of rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please enter your appearances?
May it please the court, the appellant Jamario Roberts appears through counsel Casper Shire, Kansas Appellate Defender Office. Present and ready for argument.
May it please the court, Assistant District Attorney Matt Maloney for the state, present and ready for argument.
Mr. Shire, you may begin your argument.
Thank you, Your Honor. Jamario Roberts originally received probation in both of these consolidated cases, but those probations were later revoked. For the first time in his probation revocation appeal, he challenged his criminal history. He argued that the state never met the burden of proving that several Wichita municipal misdemeanor convictions could be scored against him, enhancing his sentence. Back at that original sentencing hearing, Jamario had agreed that the criminal history reported in his PSI was accurate, but that PSI did not indicate that the municipal convictions had been counseled. The state never put on evidence that they were counseled, and Jamario never agreed that they were counseled. The Court of Appeals refused to reach the merits of Jamario's challenge, finding that Jamario had a burden to put on some evidence that the convictions, in fact, were not counseled in order to prevail. Jamario petitioned this court for review, and this court granted that. There is no evidence in the record of whether these convictions were counseled or not. As we see it, the question before this court at this point is who has the burden of proof at this stage in the proceedings. And we believe that the state never met its original sentencing burden of proof, and that under Obregon, that burden remains on the state. For that reason, we are asking this court to reverse the Court of Appeals opinion, to vacate Jamario's sentences, and to remand to the Sedgwick County District Court for a new sentencing hearing where the state has the burden of proving these municipal convictions can constitutionally be scored in Jamario's criminal history. The most notable problem with the Court of Appeals opinion in this case is that it fails to acknowledge and fails to apply Obregon. And Obregon doesn't beat around the bush. The state has the burden at sentencing to prove an offender's criminal history by a preponderance of the evidence. The district court's finding that the state met that burden must be supported by substantial competent evidence. And this court didn't pull that holding out of thin air. The holding is well rooted in KSA 216814, which places the burden of proof on the state. Here, the PSI Jamario stipulated to did not meet the state's burden. It only established that the 4 municipal convictions that we're arguing about exist. It did not prove—
Mr. Shire, I'm sorry to interrupt you, but I didn't want to stray too far from 6814. The legislature seems to have also provided a way or 2 ways for the state to meet its burden of proof, either admission in open court or determination by preponderance of evidence in subsection A. Would you agree that that's what subsection A does? And if so, why doesn't the admission satisfy the burden of proof?
Because what Jamario admitted when he stipulated to his PSI is that the information in the PSI is correct. The problem with the PSI in this case is that it does not give us any indication that Jamario was counseled, that he waived counsel or that the right to counsel never attached. So
Counsel, excuse me, the fact that it was used to score has some significance. Would you say that could be interpreted as being circumstantial evidence that they were appropriately scored and appropriately presented as person misdemeanors? That were there was no waiver or no, and they were counseled, and there was no evidence that he was that he had waived counsel, or that was evidence that he waived it. I'm sorry.
no, Your Honor, I don't think so. The problem here, as I see it, is that there's just no evidence at all. There is no suggestion that he did have an attorney, that he didn't have an attorney, that he did waive that right, that he didn't waive that right. The PSI gives us absolutely no idea. And that is what Jamario stipulated to.
Can I get into just what is the practical effect of this when there is a sentencing? You have PSI is presented. There's no objection to the PSI by anyone. And there's really not contesting that there were misdemeanor convictions. It's just whether they're counseled or uncounseled. I know that's significant. But what is the trial court supposed to do in that instance? Not impose sentence, go ahead and impose sentence and wait to see if there's an objection later raised, which is what happened here years after the fact. I mean, just what is the court to do at that juncture when no one contests the validity of the PSI?
Well, Your Honor, I think I'll say two things. First, I think, I don't think it's asking too much for district courts to look at convictions like this, to recognize that they're municipal convictions, and to know that there's an additional burden out there that the state needs to meet. I agree that best practice would have been to object here and to say, hey, we've got a problem on the defense side. And had that happened, we probably would have had this sorted out 3 years ago instead of having to argue about it today. I agree, but the district court still could have recognized that there's a burden here that the state didn't meet and not score that conviction. The second thing I'll say, Your Honor.
So if that, your position would be if that evidence isn't there regarding counseled or uncounseled or a waiver, is that you just don't score it. You don't consolidate, make them all of that mechanism that the court would go through. You don't do it if it's not there.
If the state hasn't presented the evidence to show that it can be scored, that it can be counted, then no, it shouldn't be counted, Your Honor.
Counsel, I probably have a different way of asking the exact same question, which is, didn't the PSI categorize your client's criminal history as a B?
Yes, Your Honor.
And your client stipulated to that, to the whole PSI, including the categorization as a B criminal history. And doesn't that just end the case?
No, Your Honor, it doesn't. I think it goes back to Dickey. Dickey tells us that when there is a stipulation to criminal history, it's a stipulation to the fact that the convictions listed in that PSI exist. It is not a stipulation that the ultimate legal conclusion that criminal history B applies in this case is correct. This PSI, this piece of paper here could have said that Jamario had a criminal history score of A. That would be patently incorrect. And if Jamario agrees to that, he's not bound to it. He cannot agree to an illegal sentence.
Does it make a difference that we're here evaluating the quality of the evidence versus illegal sentence?
I think this is still an illegal sentence issue, Your Honor. And it's an illegal sentence issue because the state never met its original sentencing burden. The state never met its original sentencing burden, which means under KSA 216814 and under Obregon, this is an illegal sentence and we can get back at it now. And the state still has the burden of proving it up.
And which party has the burden of proof to demonstrate the illegal sentence?
We have the burden to show that the sentence is illegal, but the illegality in the sentence is the state's failure to meet its original burden of proof. And that's evident in the record because the PSI that Jamario stipulated to did not carry the state's burden of proof.
Well, if we conclude that the stipulation to the PSI's criminal history score of B under the statute is sufficient evidence, would you concede that that means that you have failed to carry your burden of proof to demonstrate an illegal sentence?
I wanted to make sure I understand the question before I answer it, Your Honor. If a stipulation to being a particular criminal history score is sufficient evidence to meet the state's, I'm sorry, could you ask the question again?
Well, in other words, is there, when we move from sufficiency of the evidence standard to a legal sentence, because there's this burden shifting going on, is it possible for the state to meet its initial burden under the statute because of the stipulation, and for then there to be a later challenge to an illegal sentence in which the defendant has the burden to come forward with additional evidence that demonstrates that in fact this was wrong?
Yes, absolutely, Your Honor. And I think we can see that very thing happening in this case. I don't need to give a hypothetical, because if you look at Jamario's PSI, which is volume 3 of the record, and if you look at entry 14, it's a conviction, a Kansas conviction for flee and elude, which can be either a misdemeanor or a felony in Kansas. If it's charged under subsection A of the statute, it's typically a misdemeanor unless there are priors. If it's charged under subsection B, it's always going to be a felony. Now, we didn't challenge the classification of that offense as a person felony. And the reason we didn't is because if you look at number 14, the PSI indicates that it's a conviction under subsection B. So the PSI contains the information the state needed to prove to classify that conviction as a person felony. If Jamario wanted to challenge that, he would indeed have to come up with evidence that it was scored the wrong way. The burden at that point would be on him. But if you compare that to what we see in 10 through 12 and in 18, which are the municipal convictions, we don't see any indication in the PSI that the state has met its burden. We don't see any indication that Jamario had counsel, waived it, or that counsel didn't attach. And because the PSI does not lay out the information to carry the state's burden, Jamario's stipulation to that PSI did not meet the state's burden. And since the burden never got met, the sentence is illegal. That's the way we look at it, Your Honor.
Counsel, I'd kind of like to put what I understand your argument to be within the context of the language of 216814. I don't know if you have it in front of you, or if not.
I do, Your Honor.
Okay, so I think maybe my questions can be kind of shortened, or my summary can be kind of shortened. If not, and I need to expand somewhere, let me know. But when I look at that, sections A and B refer to criminal history. And if I refer back to the definition of criminal history in 6803, that tells me that what that is the list, the historical list of convictions. And the definitions then have a separate definition for criminal history score, which is what puts somebody into that category, the accumulation of the calculation, right? So A and B don't seem to reference in that strict construction sense criminal history score. But C broadens this a great deal and says the offender should object to anything on that worksheet. So it's anything as I read it. And then it sets up a different shifting back and forth, perhaps arguably. So would you agree we are talking about C and about the burden shifting that occurs under subsection C of 6814?
I agree that the state was certainly, I'm sorry.
And I
Your
guess
Honor.
I should add, which then means that the critical language is in that last sentence of that section, which says that the offender has the criminal, that challenges will have the burden, but it qualifies that if the challenges the history which has been previously established. So does 6814 even apply to your argument, which I take to be more of a criminal history scoring than it is a criminal history?
Well, as I see it, Your Honor, as applied to this case, the key language in subsection C there is criminal history, which has been previously established. And the whole argument we have is that it was never properly established in the first place. And since it was never properly established in the first place, the burden never shifted to Jamaria. It's only after the state meets its burden that the burden comes back to Jamario, and Jamario has some obligation to put on evidence disproving his criminal history score.
So I take it from that answer, you don't think there's a distinction to be made between the statute's restriction to criminal history and not its use of criminal history score?
Your Honor, I think going, as I said before, going back to Dickey, I think it's clear that if you're being sentenced, you can admit, yes, these are the convictions in my criminal history, but you cannot agree to a criminal history score which is legally incorrect. You cannot agree to an illegal sentence. And in our view, that's what happened here, because this went beyond just saying, okay, we've got these municipal convictions. The district court improperly found that the state met its burden of proving not only these convictions exist, but that they can be scored against Jamario in a constitutional manner. And because they never met that burden, the burden never shifted. That's how we view the scheme, Your Honor.
Okay. Are there other questions? Thank you. Mr. Maloney?
Thank you, Your Honor. May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I'll be the first to admit that a lot of the criminal history case law over the last few years especially has been very complicated and involved. But I don't think that it's a coincidence that in this particular case, the Court of Appeals opinion on this issue was only 2 pages long. And I think the reason why the court was able to dispose of the defendant's argument in such brief fashion was because there is a very specific guide in place to tell us how to address this situation. And that guide is 216814.
Mr. Maloney, would you also from there, could it be possible that the reason the Court of Appeals opinion is so short is because it doesn't cite any of our case law, including Obregon? And if so, how do you distinguish Obregon?
Well, I think that there are a couple of distinctions, both of which are very significant. One is the fact that unlike in Obregon, in this case, what we're dealing with is a situation where the defendant specifically admitted to his criminal history. And in Obregon, there's no indication that that actually happened. I think that was a case where maybe the defendant simply failed to object, but he did not personally agree to the criminal history. And I know some of the Court of Appeals unpublished opinions that have come down since Obregon have noted that there's no indication that he had actually agreed to his criminal history. So I think the fact that he simply didn't object is one distinction, because as Justice Wall pointed out, the statute provides multiple ways that the state's burden can be satisfied, one of which is if the defendant affirmatively agrees to his criminal history.
What would you say to Mr. Shire's argument that he agreed to his criminal history, that to the facts that were, stated, but that it's an illegal sentence and you can't agree to an illegal sentence?
And I think that gets to the second distinction between this case and Obregon, which is that in cases such as Obregon and other cases before it, where this court has said that while a defendant admits to the existence of a conviction, that doesn't necessarily equate to an admission or an agreement to the effect that those convictions have, to the overall legality of the sentence. And I think that the rationale behind that makes sense when you consider that a defendant certainly shouldn't be expected to know whether a certain conviction was properly classified. When we think about something like Wetridge or any case that involves whether an out-of-state, or for that matter, an in-state conviction of a statute that had alternative means and was divisible, and where some of those means would be felonies and others misdemeanors, and some person and some non-person, I think it's fair to say that it would be unfair to expect a defendant to be able to agree to the legal effect. But here, we're not talking about that. We're talking about a factual agreement, which is, was he represented by counsel at the time of his prior conviction? That's not the type of intricate legal matter that it would be unfair to expect a defendant to be bound by. Nobody is in better position to know whether he was represented by counsel or whether he waived that right than the defendant himself. And I think the mere fact that those municipal convictions were listed in the criminal history, their very inclusion in the PSI, is an indication that he was represented, because if he wasn't, they wouldn't be counted in criminal history at all. So it's not.
Let me ask you a question about that. And this wasn't in the briefing, so if you need me to read the statute, I would be glad to. But the precursor statute, or the preceding statute to 2168-14, is 2168-13. And it talks about the PSI and the information that's required to be included. And we assume the legislature did this so that if a defendant wants to dispute under 68-14 the criminal history, but it specifically says that under subsection 5 that a listing of prior adult convictions or juvenile adjudications for felonies or misdemeanors need to be listed. And such listings shall include an assessment of the appropriate classification of the criminal history on the criminal history scale and the source of information regarding each listed prior conviction and any available source of journal entries or other documents through which the listed convictions may be verified. In this case, the journal entry, or the PSI, as its source information, it just cites another PSI, and it wasn't attached. So we have no idea in this case, when you're handing this to the defendant, are you going to prove this or not? Well, even though the statute says you're supposed to attach the source information, that didn't happen in this case, did it?
You're correct, Your Honor. And I think that is something where it certainly does vary case by case as far as what is attached to the PSI. Some are more thorough than others, and you're correct there.
This statute requires it. So to Justice Rosen's point, where he asked what what's the practical effect? Wouldn't the practical effect be here, send it back down and get the defendant the information that the legislature required, which would include the source information, which would include whether or not it was counseled.
I think that that's where the statute, though, and speaking to 6814, I think that's where the statute does specifically say, though, that if a defendant wishes to challenge any portion of the criminal history or of the PSI, that he is to file and make such a request at the time of sentencing and immediately specify what exactly he's objecting to. And so while
object when the state didn't meet its burden in producing the PSI to produce the documents upon which the defendant could object.
Well, he can always object. I mean, he can always object if he doesn't think that the PSI is sufficient. I mean, he could make that very objection.
Whose burden is it to provide this information?
Well, because he admits
No,
that
whose burden
satisfies.
is it under the statute to provide the source information for the PSI, which would allow you to go back and look and see whether it was counseled. Whose burden is that under 6813?
I don't know that 6813 specifically says that it's the state's burden to, I'm not having the statute in front of me. I don't know whether it specifies that it is the state's burden to make sure that the PSI includes those things, or if it just speaks in general terms as far as what the PSI is to include. If it specifically says the state, then I certainly wouldn't argue with the language in the statute. But I think my point would be, regardless of that, even if the PSI is in some ways deficient, 6814A tells us that the offender can admit to his criminal history in open court. And so even if the PSI is in some way deficient, if a defendant comes into open court and agrees that what is in there is accurate, even if it is in some theoretical sense or in some legal sense lacking some of the information that's supposed to have, then our position would be that his admission does serve to meet the state's burden in that situation. And then as a result, it ends up being shifted to the defendant from that point forward.
But the statute says that the PSI is the state, that the PSI can meet the state's burden.
Then I think in this situation, then I believe my response would be that this is a scenario then where the state is not relying on the PSI to have met its burden. We're relying on his admission. And that again gets to Justice Wall's question to opposing counsel. The statute provides two different avenues by which the burden can be met. One is through the PSI, the other is through a defendant's admission. So if the defendant in this case, like Obregon, if he had not personally admitted to the criminal history, then the state would be in a more difficult position to the extent that the PSI itself is deficient. But
what about just briefly comment on what Justice Lukert said, that perhaps that this statute just deals with criminal history scores and doesn't deal with the actual existence of the criminal history, as opposed to the scoring and the classification.
And I do understand that question and that distinction. And I think, again, maybe that's part of what's driven the earlier case law with respect to saying that while a defendant can stipulate to the existence of priors, that doesn't necessarily mean that he or she has agreed to the legal effect of those. But that's where I do think it's important to note that in this particular case, we're not talking about a legal distinction here. We're talking about the factual matter of whether he had counsel or waived counsel in those prior cases. And I know one of the panels that has addressed this type of an issue before has noted that the 6813, while it does require the PSI to list prior convictions, it does not require that the PSI specify whether those prior convictions, especially misdemeanors, were counseled. And so in this particular case, setting aside the point that you already made that it maybe lacks some of the overall documentation that should have been attached to the PSI, the fact that it didn't specify whether those misdemeanor convictions were counseled, that's not a deficiency in the PSI, because that's not required by the statute.
Let me ask you a question. In the Dickey line of cases, when there was a factual issue about which subsection of a statute in an out of state, we remanded it, right?
Correct. But
And you could look at, you could look at documents or other kinds of things to determine. So why isn't that the case here? That's a factual situation.
I would still draw a distinction and say that is also a legal question, because the reason why the question of which version you were convicted of is important is because under various legal theories, some versions would be classified as a person and some as a non-person. And so there's that question about what is the legal effect depending on whether you're convicted under one section or subsection or another.
But couldn't you say the same thing about here, that the legal effect of a counseled misdemeanor versus uncounseled or waiver?
But I think the distinction is that an uncounseled, a misdemeanor that is obtained in violation of the right to counsel would not be in the criminal history, would not be counted against a defendant's criminal history score at all. There's not a classification. There's no discussion here, or there's no dispute about saying, well, if it turns out he was uncounseled, then it would be a misdemeanor as opposed to a felony, or a non-person as opposed to a person. It's flat out that this would not be something that could be included in the criminal history score at all. And again, I think that there's no, I guess where I really struggle is looking at this at 6814 as a whole and talking about who the burden is on at various stages. And then when we get down to subsection C, saying that once it's been established, the burden shifts to the offender. And I struggle to understand in what situation is the burden ever shifted to the defendant, if not in a situation where he stands up in open court and says, yes, I agree that my criminal history score is correct. It's been established at that point. And I want to make clear, I mean, I think this is clear, but I just want to emphasize, the state's not taking the unrealistic or unfair position that the defendant shouldn't still be entitled to raise this type of claim. We admit that he certainly can. And as this court has told us, while we might disagree, that he can even raise it for the first time on appeal. We're simply saying that in this particular circumstance where he stood up in court and said, yes, I agree that my criminal history is B, all we're saying is that he should now have the burden. And if this situation doesn't shift the burden to him, I struggle to come up with any scenario where a defendant truly would be foreclosed from saying, no, the state still has the burden, because even though I admitted to it, I didn't make this particular argument, or I didn't make this particular admission. There are tons of things, tons of arguments that a defendant can come up with after the fact and say, well, yeah, even though I agreed, nobody specifically asked me whether I agreed to this or to that. So from a practical standpoint, if a defendant in this scenario is not held to the burden shifting to him by a preponderance of the evidence, I struggle to come up with a scenario where that will in fact be held to him. So again,
I'm sorry.
Go ahead.
Can I parse that a little bit? Because there were times you said he agreed to the criminal history, and there were times you said he agreed to the criminal history score. And I really think that precision may be important in light of what I was discussing under 2168.14 with your opposing counsel. And my understanding is that the defendant stipulated to the criminal history. Is that incorrect? Did he actually also stipulate to the criminal history score?
I believe that in this case, he actually did stipulate to the score. And certainly I don't want to misrepresent. So if the record shows otherwise, then I would defer to that. But I believe in this case that he actually did stipulate to his criminal history score of being B. I don't think it was a scenario where he simply agreed that, yes, I was convicted of X, Y, and Z in those municipal cases. I think that he did make an overall admission that his criminal history score was properly calculated.
And then another part of that is that sometimes you said it, or at least it was unclear to me what you were saying. Is it your view that if I have committed a misdemeanor in my past that was uncounseled, it should not even be listed on the on the PSI?
And I appreciate that question, and I recognize, I think I may have spoken unclearly, or I may have even just flat out misspoke, especially in light of what Justice Standridge pointed out, that under 6813, that the PSI is to include a list of all prior convictions. And so to the extent I suggested otherwise earlier, I would certainly recognize that that was a mistake on my part. But I think that to the extent that the PSI shows that those convictions not only occurred, but then lists them as prior convictions of a person misdemeanor that is not only existed, but is being scored as criminal history against the defendant in this case. That's where I think there's still significance to the fact that the PSI shows in those little 3-letter codes next to each conviction, where it will say whether something is an adult or a juvenile, misdemeanor, felony, person, non-person. So to the extent that the PSI also shows one of those designations and shows that it is being not only that the conviction existed, but that it is being scored against the criminal history, and that in this particular case, then I do still think that it carries significance that it was listed as such in the current PSI, and that the defendant saw that and not only didn't object, but again, that he agreed with his criminal history score.
Counsel, these two misdemeanor convictions were both for battery. Is that correct?
I certainly have no reason to dispute that. I don't know that it was ever that he ever focused on what the convictions were for, so I don't recall off the top of my head, but I'm sure you're correct about that.
Well, if they are battery, doesn't that indicate that they would have carried a potential for prison time or jail time?
I believe so, Your Honor. And again, this is another challenge about the fact that this is being raised for the first time on appeal, as that, at this point, the defendant's just making this broad argument that, well, we don't know. Maybe he had counsel, maybe he didn't. Maybe he waived counsel, maybe he didn't. Maybe it was a crime that did carry with it the potential for incarceration, and maybe it didn't. And I think that's the other critical thing that I want to emphasize in this particular case. And I think the Court of Appeals did a nice job in focusing on this. We don't even have a situation here where the defendant has ever made a good faith allegation that his right to counsel in that case, in any of these cases, were in fact violated. This is nothing more than a pure hypothetical. And I would note that while we all can agree from a practical standpoint that there's no real concern that in felony cases, a defendant would have his right to counsel violated, there would be nothing foreclosing a defendant from even making that argument and saying, hey, there's nothing that specifically shows that my right to counsel in my prior person felony convictions was not violated. So again, that gets back to my point that there's really no limit to the amount of speculative allegations that a defendant can make. A PSI, and back to Justice Standridge's point, there is a statute that guides and tells us what should be in the PSI, but even the most thorough PSI imaginable is not going to be able to cover every possible hypothetical that a defendant could throw at the wall on appeal for the first time and say, hey, we don't know X, Y, or Z because the PSI didn't show it. So I think especially in a case where the defendant has never made an allegation that his right to counsel was violated, that should further bolster the argument that at this stage of the proceedings, the burden should be on the defendant under subsection C, because he admitted to the criminal history at the time of sentencing.
Other questions? Thank you, Mr. Maloney.
Thank you,
Mr.
Your Honors.
Mr. Trier, you reserve 3 minutes.
Thank you, Your Honor. I'd just like to make a couple of quick points. The first would be that Jamario really did not stand up at sentencing and agree that his criminal history was a B. I just pulled the volume 5, which is the sentencing transcript. And on page 2, it reads like this. The court says, criminal history in both cases, according to the PSI, scored at B. Does counsel agree upon the criminal history in each case? Defense counsel, no objection, judge. Court, Mr. Roberts, do you personally admit that the criminal history is correct? Jamario, yes, Your Honor. So to me, that very much reads as he's admitting to the criminal history and not to the criminal history score, to the extent that makes a difference. The second thing I wanted to say, which is a bit of a broader point, look, I can absolutely understand that the state doesn't like the way this is playing out. I don't love the way this is playing out either. I don't necessarily disagree that the claims that we're making here are speculative. I freely admit, I do not know what is in those journal entries. I do not know what is going to happen if this case gets remanded.
Counsel,
Yes.
I guess I'll interrupt you there and just ask, based on what you just said, it sounds like the implication of us agreeing with your position is that virtually every sentence that includes some criminal history score is illegal. Because as Mr. Maloney pointed out, none of the PSIs indicate affirmatively that prior felony convictions were counseled or not counseled.
And to the extent that's a problem, Your Honor, I think the ball is in the courts, in the state's court to fix that in the way that Justice Standridge, I think, has been suggesting, which is to
Well, so just to clarify, you're agreeing with me that if the court adopts your position, that renders every single sentence illegal that included a prior conviction.
No, I don't agree, Your Honor.
Well, why not? If let's just take hypothetical case where there's one felony in the criminal history, you would agree with me that if that felony was in fact an uncounseled conviction, it could not be scored.
Yes, Your Honor.
And none of those PSIs, I mean, in none of those cases does the state affirmatively demonstrate that that conviction was counseled.
That's true, Your Honor. I have two responses to that. First, they very easily could and probably should, and they should be attaching journal entries as well. And two, there is a statutory requirement in felony cases that counsel be appointed. That is certainly
there's a constitutional requirement in misdemeanor cases under Youngblood and Dela Cruz. I mean, that's the whole legal foundation of this. Is it's a constitutional requirement.
And I think that sort of ignores the fundamental reality that we know about the municipal courts, is that municipal courts are different. We do not see clients in municipal court, or excuse me, in a district court. There's a statute that says an attorney has to be appointed. District courts in Kansas especially, I don't have the statute ready, but there's a statute that says you have to appoint an attorney. There is nothing like that in municipal court.
Are you suggesting that it's reasonable for us to draw an inference from a felony conviction that it was counseled, whereas it's not reasonable to draw that inference from a misdemeanor conviction?
I think it's much more reasonable based on the statute that says that you have to do it in a felony case than it would be in a municipal case, Your Honor. And I see that I'm out of time, so unless this court has further questions, I will simply ask this court to reverse the Court of Appeals, to vacate Jamario's sentences and to remand for a new sentencing hearing.
Thank you, counsel. Thank you to both counsel for your arguments this morning. The court will take this appeal under advisement, and we will be in recess until 1:30 this afternoon.
Thank you, Your Honor.